R. Dunn, Jr., and others.
May it please the Court. I'm Ken Bell with Clark Partington on behalf of Lynn Dunn, the appellant. I would like to reserve 3 minutes for both rebuttal and my response to the cross appeal, if I could. Your Honors, there are a lot of issues that have been raised in the briefs here, but I think there are two fundamental issues, and the first is by far the most important. And the question is, how much character assassination are we going to allow in a court of law? It's a bane of our...
That might have something to do with how many objections are stated.
Exactly. And I'll get to that point. But a bane of our culture and our discussion of serious issues is that we quickly turn to ad hominem attacks or attacks on persons, attack on character. Florida evidence is very clear in our courts of law. We erect barriers to what might be relevant for historical purposes or outside of courtrooms, but in courtrooms on legal issues, we erect barriers to keep irrelevant, legally irrelevant, character evidence from the trier of fact. Now, you raised the issue of how many objections. In this case, there were 3 objections to the evidence. The very first one occurred at the very beginning when Lynn Dunn was placed on by the plaintiffs, the appellees in this case. They placed her on the stand, and one of the first questions that they asked her was, well, were you pregnant at the time that you married Mr. C., who was a person she had married 30 years ago in 1972? It was objected to as being on the basis of relevancy, which is the proper objection because it is in Section 404, which deals with relevancy. And the simple response was, well, that goes to show a pattern of conduct. And the judge immediately said, overruled.
Do you contend that the objection was sufficiently specific?
I think it was in this case because if you look at the first instruction this court gave, and if you know this judge, he said, I don't accept speaking objections, make it brief, make it short. And he'd never provided an opportunity. He never even listened to that objection. Then it goes on, and there's the second objection has to do with she had a short-term marriage that was annulled because she and the gentleman she married, Mr. Parsons, got drunk, and this was later, in 1984. It got annulled, and counsel was asking her, well, did you get drunk on other occasions? Objection, Your Honor, relevancy overruled. It goes to the pattern. The judge was not listening to and not doing what you wrote in the Vice case, Your Honor, was the court has to cautiously scrutinize this evidence. And the difference between the typical case where you have a different trier of fact than the judge, where the judge is serving as the gatekeeper, here the trial judge has to make the very difficult decision to wear 2 hats. And the first half is to make the ruling on evidence, and the second half is to, when making his decision, only rely on relevant evidence.
Well, counsel, it seems to me there are only a couple objections here, and we're talking about thousands of pages of record in this case. Lots of testimony by ex-husbands, exhibits offered with regard to these marriages. What evidence precisely are you arguing should have been excluded by the court? Would that be any evidence of the marriages, any testimony by the ex-husbands?
You know, if we could look at the judgment, because I think the key thing here is not only that it was introduced, but that it was relied upon by the trier of fact. And if you look at his final judgment, beginning on paragraph 11, he goes through the history of Lynn Dunn. In paragraph 12, he says, Lynn Dunn first married an American serviceman, Kenneth C., in September of 1972. She was pregnant at the time. She advised Kenneth C. of her pregnancy when she was 18 years of age, and shortly thereafter married her first husband. I don't know what relevancy to this case, the allegations in this case, her marriage and the pregnancy at the time, 30 years later had to do in this case.
Well, the police have argued that it goes to her motive in marrying Mr. Dunn, and that she, in 2 prior marriages, had offered that she was pregnant prior to the marriage, and there's record evidence that she did the same with Mr. Dunn prior to marrying him.
Yeah, and the key part is the error in the supposition that they draw from the fact she got pregnant. One, Mr. C. never testified, and there is no evidence of the record that she used or manipulated Mr. C. by getting pregnant in order to get married. And the real critical, and the fact that you do have, is that Mr. Griffin, he was specifically asked that in his deposition by plaintiff's counsel, well, basically, did she use the pregnancy to manipulate you into getting married? No, I don't think so, not even 1%. So there's not even any competent, substantial evidence to support the supposition that she got pregnant or manipulated these other husbands by getting pregnant in order to get married. There's no evidence in the record.
I recognize that it's cited in the final order, and it's certainly a dramatic final order, if you will. But is it not true that it could be harmless error, assuming we even agree with you, because of the standard of proof regarding undue influence, and which goes more towards the mental state of the testator?
I don't think it can be determined as harmless error in this case. When you go to the final judgment, the judge specifically relies upon this finding in his finding of the undue influence in paragraph 56A. He says the defendant, this is the first finding that was part of the supposition of that determination of undue influence. The defendant, Lynn Dunn, is predatory. The defendant has a long-standing history of parasitic, manipulative, and callous behavior. Her pattern of behavior, which I submit is nothing more than pure propensity or bad character evidence. He says her pattern of behavior spans decades, wherein she targets vulnerable men. There is no evidence these other men were vulnerable, and the only argument presented by my opposition is that they were vulnerable because they were to her feminine wiles, and they were military men, and they were vulnerable, albeit in different ways. What is that more than mere bad character or propensity evidence? So he says her pattern of behavior spans decades, wherein she targets vulnerable men, engages in romantic encounters, and uses the resulting physical relationship to enhance her physical status and well-being. And I submit there's no competent, substantial evidence to support any of that as far as the prior marriages. There would be as to Mr. Dunn, and that's what they should have focused on, is her actions with Mr. Dunn, and not to impugn her character by the prior 30 years.
Do you think your trial counsel below had an obligation to file a motion in limine? If this was a type of judge who demands speaking objections and won't listen to extended argument, doesn't counsel have an obligation to then present?
Here's the dilemma counsel has on that in the judge trial. Unlike in this case, where if I started to speak on matters outside the record, you wouldn't consider it, it would be stricken, it wouldn't be part of the record. The motion in limine works when you have a different trier of fact, when you have the jury panel and this judge is acting as the gatekeeper, and he goes through the analysis that the judge goes to invite. The problem in this case, you file a motion in limine, then the appellant does what they suggested to do when some evidence was kept out by the judge, is to proffer the evidence. So you get the same evidence before the trier of fact, and they are in effect tainted. What you're concerned about is the judge is made aware that there's an issue of improper evidence going in, and that was done by the first objection at the very beginning, and he just curtly overruled pattern of conduct.
The problem that you have identified goes to the undue influence holding, but there was also a finding that he was non-compass, at least towards the end.
Right. As to the competency finding, right. I don't think it would go as to the competency finding in October of 2005.
You're not asking us to overturn the last 7 deeds, the setting aside of the last 7 deeds?
No, I'm not really concerned about the last 7 deeds. The problem to me is the entire structure of this trial, and that's why you have so many issues before you, was tainted by this trial judge. He did not consider all of the evidence as a whole. He was tainted. That's the whole reason, if you look at the hooligan case that I sent you, a supplement, the case says that when character evidence is introduced only as circumstantial evidence of conduct, there is too much danger of surprise, prejudice, and distraction from the issues. And that's what happened in this case. That's why you have a punitive damage award that comes after we have a hearing on the question of whether there should be an accounting determination in a constructive trust when it was never requested, and it was only requested in an action that was dismissed after the plaintiff presented their case. It goes to the issue of compensatory damages when you have a schedule that does not, when it was supposed to be for damages from property sold from the trust, and there's no competent substantial evidence in the file that $300-something thousand of that money was ever property sold from the trust. It just said various states. It just filters throughout the whole process, and that's the concern about the character evidence, is that it will impact or affect the verdict or the determination, and that's what happened in this case. And that's where the harmful fundamental error comes from the legion of cases with character evidence, is that it is unfairly prejudicial.
Counsel, the amount of character evidence in this case, again, we go to the lack of objections. I mean, there were hours and hours of testimony about Ms. Dunn's character, not just with regard to the pregnancies, but with regard to naval criminal investigations of Ms. Dunn.
Right.
With regard to all sorts of financial transactions she had engaged in prior to the marriage, post-marriage, her gambling habits, and again, all without apparent objection.
Right.
And so, again, you know, what I really want to focus on is exactly what character evidence in this record you're suggesting the trial court impermissibly relied upon.
The fact that she targeted any evidence from the prior marriages, like her determination of who the kids would live with or not live with. The question about whether her daughter's stepsister's stepdaughter's statement in some cruise about pregnancy with some other boyfriend goes to Lynn Dunn's pattern of behavior or pattern of conduct. It just goes throughout the whole trial.
But you wouldn't exclude the evidence, for instance, of the naval criminal investigations, of her gambling habits, of her expenditures, would you?
No.
That wouldn't at all go to her motive in marrying Mr. Dunn?
Well, I take that back. Yes, I would, because how is that similar fact evidence in the sense of it's strikingly similar? The fact that she gambled before, what does that have? She didn't deny gambling in this case. It wasn't a material issue of fact, and that's the critical point, is because 404.1 precludes this evidence, and it says it cannot be used. 404.2 says you can use it in limited circumstance if it's similar fact evidence. It has to be strikingly similar. There is no striking similarity. Secondly, it has to go to a material and relevant issue in fact. It doesn't go to a material relevant issue in fact that she was gambling. She wasn't hiding that from anybody. She was going with her husband and other friends.
Let's just take the naval criminal investigations, for instance, which occurred just a year before she met Mr. Dunn while she was still married to Mr. Griffin. Was that properly admitted?
No.
In your view?
If you try these cases, she wasn't found guilty. The mere fact that there may have been an investigation is no proof of a conviction. That would be like saying in a criminal case, well, weren't you charged with battery and weren't you charged with this? Didn't they investigate you with this? Didn't they investigate you with that? We don't allow that in any court of law. And that's why I'm saying we allow it if there's a conviction.
But if you've got a single civil case, judge trial, where the judgment is reversed because testimony was allowed in, there having been no objection.
No, and I don't have a case that supports the contrary to that, because I think the reality of it is we expect judges to filter, and again, here's the critical point. We're not saying that
Your argument is we don't have to speculate here, it's all through the final order.
Exactly. He relied on it. That's the critical point here. We expect these judges to be able to wear both hats and wear them well. What happened to this judge is you don't have to guess and question like you do in a criminal case if it comes in whether it impacted the verdict. And that's the issue. We put the burden on the state. In the Vice case, the state had to come forward and prove that it didn't impact the verdict. You don't have that question here. You know it impacted the verdict because the judge relied on it expressly for his findings throughout his final judgment. And it has been clear that we have acknowledged that's unfairly prejudicial, improper. And so if the objections were not sufficient to sustain it, and if he had not relied upon it, I agree with you wholeheartedly, there would be no sufficient basis to overturn his ruling. But that's not the if in this case, because he relied upon it throughout his findings and throughout his decisions in the entire case. I'd like to reserve whatever time I have left.
May it please the Court, my name is Louis Rosenblum, and I represent the appellees. We do have a cross appeal, but in the interest of saving time, we'll stand on our briefs on that issue, so I won't reserve any time for the cross appeal. And also, I will limit my argument to the similar fact evidence, since that's the only thing that Mr. Bell had time to get to. One thing I want to make clear at the beginning is that it is true, and this record supports it, that Judge Swanson doesn't like speaking objections. But what Mr. Bell didn't point out is what he told counsel at page 5 of the transcript at the very beginning. And Judge Swanson said this, and I quote, "Now, after I made a ruling, if you believe you need something else for the record, let me know. I'll make an assessment about whether or not it's going to be permitted, and we'll go from there." Well, there was never any suggestion by trial counsel, who was not Mr. Bell, that they had anything in addition to offer. Moreover, the Mrs. Dunn filed 2 very extensive motions in limine before trial, neither of which had anything to do with the similar fact evidence. So they obviously knew that it could be done in a judge trial, and it was appropriate to do in a judge trial. Further, the plaintiff, Mrs. Dunn, filed a 23-page trial brief in advance of trial, and there is not one note in there about any evidentiary problems that were anticipated during the trial. So from my perspective, this is a classic example of a waiver by failure to object. Now let's talk about the specific objections. I will agree that the word relevance, probably in the generic sense, includes the similar fact evidence from section 90.404. But based on the extensive argument in the briefs, it is hardly fair to the trial judge to say, Judge Swanson, you should be reversed, when Judge Swanson never had the opportunity, either before, during, or after trial, to deal with this argument. Further, they argue, well, this is a 403 case where any probative value was outweighed by the prejudicial effect. Right. There was never any request for the trial judge to do that kind of weighing, and it probably doesn't. I believe you're arguing it doesn't even apply. It doesn't even apply to a trial judge, and we've got to give the trial judge, whoever he or she is, some credit here. They know how to separate out the prejudicial stuff that probably isn't relevant, and well, that'd be more convincing if it didn't show up in the final order. Well, there's no question he relied on it. We don't pretend that he didn't rely on it, but we would also contend that the record has ample evidence to support the trial judge's ruling without the similar fact evidence. I think that's apparent. I mean, the court has obviously seen how extensive Judge Swanson's findings of fact and how meticulous he was. He listened to, and the suggestion that he didn't consider all the evidence is just not supported by anything in the record. You don't have to make a list, if you're the trial judge, of the evidence permitted offered by the other side that you didn't find persuasive. And what it really came down to, Your Honor, what it really came down to in this case is there were 2 versions of the evidence. Mrs. Dunn said that Mr. Dunn was a grown man, he was an adult, he had the right to do what he wanted to do with his estate. He had a falling out with his son, so he decided to give all his assets to his wife. That's her version. But the other version, which is supported by the evidence, is that Mrs. Dunn went about intentionally to drive a wedge between Mr. Dunn and his sons, so that they would become so mad at each other, he would give everything in his estate to her. And she was successful until the courts intervened. Just give you one example.
So it's her fault that the son wrote the letters to his father saying he was going to burn in hell, or worse than that?
Well, yes. There's competent substantial evidence to support the conclusion drawn by Judge Swanson, as hurtful as those letters were, that it was all instigated by Mrs. Dunn. For example, she told, this conversation was overheard by Mr. Dunn's, I guess it's his sister-in-law, that Lynn Dunn was in California talking to Joe Dunn on the phone, and she was telling Mr. Dunn that none of your children will take care of you, only I will take care of you, when in fact, Mrs. DeCalvo, who was the sister-in-law, she knew that all 5 boys had made arrangements or had offered to let the dad come live with them, and one of them had even built an addition to his house just to accommodate their father. So this was her plan from the beginning, and the similar fact that, her modus operandi was obviously to seek out these vulnerable servicemen.
All right, now, originally there was a claim for annulment, is that right?
There was a claim for annulment that the court rejected, that she had perpetrated a fraud, et cetera. And the court rejected that based, I believe, on California law where they got married. But let me, if it pleases the court, I'd like to finish my point about the failure to object. Mr. Bell said, well, there were 3 objections. Well, the third objection that he cites was, the question was to one, I think it was one of Mrs. Dunn's daughters, well, did so-and-so go on a cruise? Well, then the objection was relevance, and Mr. Green, trial counsel for the Dunn, said, no, it's a pattern of conduct. And when the pregnancy question came up, there was no objection. And also, you talk about what other evidence is there in the record. The psychologist, Dr. Larson, who testified for the plaintiffs, without any objection, not one, he went into all of this evidence about her manipulative behavioral traits that he determined from testing, that she ranked in the 99 percentile for psychopathic manipulative people, and that's using a prison population, not an outside. So there's tons of evidence about her manipulative behavior in this record without even getting into the similar fact evidence.
And I'd like to address that exactly. On the claim of undue influence, the case law from this district is that influence must be such a degree that there is a destruction of the free agency and willpower of the person who is under the influence. Given the discord between Mr. Dunn and his sons, much of which predated his relationship with the appellant, is there competent substantial evidence in this record to show that the appellant destroyed Mr. Dunn's free will?
Yes. And the friction that between the sons and the father that took place before the father met Mrs. Dunn was not like the friction that occurred after. It got, frankly, pretty bad between father and sons. And yes, we think the record is strong that she created that. But to directly answer your question, undue influence, as the case law says, is never established by direct evidence. It never can be. I suppose there would be a case. But the inferences from this record, just give you one example, is when Mr. Dunn was on his deathbed on October 30th of, I guess it was 2006, Mrs. Dunn apparently contacted a woman that had done some closings for them and gave her instructions to prepare 7 deeds, transferring property to...
He says he's not challenging in
Well,
with respect to
I know he's not challenged the competency, but this has to do with undue influence also, about what her motive was. She had this woman prepare the deeds and listed Mr. Dunn as the preparer, which of course was not true. And she admitted, the title clerk or whoever it was admitted that she had not done that. And they take these deeds up to the hospital when he's literally on his deathbed and got him to sign them. Now, that's part of her plan. Now, it's true he wasn't competent and those deeds get set aside regardless. But this was part of her plan to exert her will. When the two of them met, you got to put this in perspective. She was in her 50s and he was in his 70s. He was an alcoholic. He was a diabetic. He had serious heart conditions. He could hardly walk at times. And what in the world? Why would she be attracted to him? One has to wonder. And I think, and if you look at the record as a whole, what happened over the next 5 years, it's pretty clear what happened. There's evidence that she withdrew from bank accounts that she got access over $3 million, and she put herself in a Mercedes and so forth. And they can say all they want. Well, he loved her and he wanted her to have all this. Fine. But the judge who saw it all, who saw her demeanor as a witness, which he described as cold, he's the trier of fact. And then she even confessed what she was up to. She was out in California at the sister-in-law's house and asked her a question. He said, if Joe and I get married, do you think it'd be okay if he gave all of his estate to me, or words to that effect? And of course she said, no, it's not okay, because his first wife worked hard to create that estate and so forth. So she was already feeling out the relatives for her plan. And then there's the DVD, which you've read about in the briefs, and I don't know if the court's had the opportunity to watch it, but there's two ways to look at that DVD. You can say, well, gee, they were having a great time. But the other way that the trial court, who saw it all, interpreted it, is that she made this statement right there on the video that they were celebrating not only Mr. Dunn's birthday that night, but 6 months had passed. I'm not sure about the significance there. And so they would, since they've been married, so there'd be no annulment now, and that if you wanted a divorce, it was going to cost you big time. So, I mean, I can't recite everything that's in this 5-day judge trial, which if a jury was involved probably would have taken 2 weeks. But the evidence is overwhelming that she exerted her will over him and made him do things that he was not otherwise inclined to do. Now, was he competent when he amended his trust? Yes. The trial judge found he was competent, but competency and undue influence, as we know, are two different things. So I would respectfully submit to the court that when the record is viewed as a whole, the criticisms of the trial judge are unfair.
The Fourth Amendment to the trust agreement, how did that work to her advantage?
Well, you have to understand also, it really...
Did you understand?
I think so, and I'm not as familiar with the subtleties as perhaps I should be.
I believe the Third Amendment said 20% to one son,
right.
20% to one son, 10% to two charities. And then the fourth iteration was 40% to
right.
one son.
But there was nothing left in the trust.
But my question is, how did that amendment work to her advantage?
Well, at that time there was, when it was executed, there was assets in the trust. But at the same time, you know, he executed a new will.
How did the reallocation from two sons to one son work to her advantage?
It probably didn't, technically, but she was, in the meantime, they were funneling all these assets out of the trust, and then he executed a new will, which left her a substantial portion, and 50-something%, and then he left the rest to a certain number of grandchildren, and to show that he really wasn't fully with it, he got the number of grandchildren wrong and so forth. I've got 2 minutes left, and I just wanted to address a couple of things that Mr. Bell mentioned in his argument. First of all, you have to understand the concept, and I know the court does, about inferences from the evidence. Just to reemphasize, rarely in a case of undue influence do you have direct testimony. I saw him, her with a gun, holding it to his head while he signed the will. You don't get testimony like that. So you have to look at all the inferences from the evidence. Number two, Mr. Bell brought up this thing, or maybe it was in the court's question about the naval criminal investigation. I could be corrected, but I don't think that was ever in evidence. I don't think that ever came in. It may be somewhere in the record, but my recollection of reading the trial record is that it is not in there, but I could be wrong. And the final point I want to make is we do believe that the harmless error is an alternative ruling, although I don't think it was any abuse of discretion for the trial judge to let this evidence in, particularly when he was a trial judge, not an easily influenced jury. And all of the cases that Mr. Bell cites, including the supplemental authority cases, are jury trials, and they are cases where there was an objection. I think two of them had motions in limine, which is the correct way to handle this. And one final point, you asked if one of the judges asked if there was any authority, judge trial reversing. I don't know of any, but one thing I did check, Mr. Bell in his reply brief has argued fundamental error. And I know from my research in the last 10 years that I went back, this court has never reversed a civil case based on fundamental error, with the exception of one administrative law case that involved a constitutional provision. So for all of these reasons and the reasons in our brief, we respectfully urge the court to affirm.
We've got 12 seconds. On the homestead issue, I just asked the court to look at the arguments that were presented by Mr. Green in the hearing that they had on this. He basically said the trust protects her homestead interests as a life estate, and the court relied on that issue. The law is clear that fundamental error under 90.1043 is reviewable regardless of preservation. So that's a red herring in this case. It was relied upon. It was fundamentally unfair. And if there was so much evidence, as Mr. Rosenblum suggests, from her relationship with him forward, there was no reason to go backwards and to do so, and for the court to rely upon that as the essence and the warp and woof of his whole opinion is based on 30 years, 3 decades of her prior history. That's nothing more than propensity. And Duncan versus State says that's wholly impermissible. And I appreciate your time and ask that you reverse the trial court decision and remand it for a trial before a new judge. Thank you.
All right, thank you.